Welcome to a Practice Pro CPD, brought to you by LAWPRO.
Good morning, and thank you so much for joining us. Welcome. My name is Judah Strafchinsky. I'm the director of Practice Pro, which is LAWPRO's Claims Prevention and Risk Management program. I'm speaking to you from Toronto, which is also where LAWPRO is located, where I'm located, and where one of our co-presenters, the Toronto Lawyers Association, are located. I acknowledge respectfully that Toronto is on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, and the Haudenosaunee and the Wendat peoples. It's now the home to many First Nation, Inuit, and Métis peoples, and is covered by Treaty 13 with the Mississaugas of the Credit. As this meeting is virtual, we're not all gathered in the same place, and for many of you, this land acknowledgement is not for the territory that you are on, the traditional territory where you reside. And if that's the case, we invite you to take some time and learn and reflect and acknowledge the traditional territory and the treaty lands that you're on. As a resource, we encourage everyone to take some time today to visit the website native-lands.ca to search the location where you're located, and you can find the appropriate territorial acknowledgement under the resources tab and learn about your local friendship centers as well if you're looking for more guidance. I'd like to recognize the long history of all First Nations in Ontario and the Métis and Inuit peoples. We thank First Nations people who lived and live in these lands for sharing them with us in peace. So again, thank you for joining us for this LAWPRO CPD event, which is part of Access to Justice Week, which is presented in partnership with the Toronto Lawyers Association. The event is Access to Justice in Practice, tips for successfully building access to justice into your law practice. And so we're here to talk about ways you can incorporate A to J initiatives into your practice effectively. And what we're going to stress today is that there's no one way to do it. We're going to talk about some of the ways that work, about the different career paths that you can forge for yourself, and ways in which Ontario lawyers and other legal professionals have incorporated A to J initiatives into practice. So today we're going to divide our about hour and a half together into 4 thematic discussions. First, we're going to meet the panelists, and we'll go around the table because, frankly, I am thrilled with the people we have here who have given their time and expertise today. We're going to learn from some real experts from a variety of areas in the province, doing a variety of different types of legal work, serving a variety of people who desperately need our help. And so we're going to go around the table and just hear who's doing what, how are you doing it, how did you get involved? And it'll show you, hopefully, that there is no wrong door to providing access to justice through private practice. Next, we'll talk in really practical terms about balancing access to justice with other pressures that you might be facing to manage your practice. It is possible to dedicate a practice to A to J and make a living. It's also possible to practice in areas where clients do not have A to J issues generally, where you're serving other populations where legal needs are regularly met, while you also give time or resources towards A to J clients and causes. So we'll talk about some of the real factors that need to be taken into account in your practice when you consider the balance that works for you. Third, we'll talk about competence issues that arise in A to J and how you can get effective in delivering legal services in the areas you've decided you're going to tackle where there are unmet legal needs. And lastly, we're going to provide some real practical tips on how you deliver those services in a way that reduces your risk so that you can do it with confidence and you can do it in a way that builds your reputation and enhances access to justice generally. So we put some resources together. I think you've now seen them in the chat function for those of you who are with us live. For those on the replay, you can find it on the CPD resource page. But those link to many different types of resources depending on your area. Some of these may be perfect, some a little less so, but we've tried to cast a broad net here to help everyone here. So the speakers, I'm not going to spend much time introducing them because you have their full bios in the materials, but Erin ORourke is with us. She's an employment and immigration law lawyer with Erin ORourke Law. She's a lifelong advocate for improving access to justice and has an awesome podcast called Off the Tracks. I encourage you to have a download and have a listen. Neha Chugg practices criminal and family law at her law firm Chugg Law Professional Corporation in Cornwall, Ontario. Leslie Ann St. Amour is at Durant Barristers. I had the honor of finally getting to hear Leslie Ann when she gave a free CPD for the first National Day for Truth and Reconciliation on September 30th. The program is available as a replay. It is excellent. I encourage anyone who has not seen it to do so. And Will Horn from McCarthy's, who is a wonderful advocate and who has been involved not just in the associate group at McCarthy's and writing and bringing clarity to complex issues that involve all of us, like the impacts of global warming on how financial transactions and insurance might go in the future, but also is dedicating lots of time and effort to the 519 clinic in Toronto, and Will's going to talk more about that. So let's talk about this no wrong door approach. So in Access to Justice, we talk about how there's no wrong door for people who have unmet legal needs to seek them. It doesn't matter whether they're in a hospital and a triage social worker recognizes that there might be a problem with the legal component and puts them in touch with, if they're lucky, PBO's embedded lawyer at a children's hospital or a legal aid clinic, or to a lawyer or to the Law Society's referral service so that they can get someone to help them with an unmet legal need, or whether they've recognized straight up that they need help and they come straight into your office. There is no wrong way for people to figure out they've got a legal issue and to seek help. And similarly, if we take that access to justice theme, there's really no wrong way for lawyers in private practice to try to find channels to facilitate access to justice. So we know that people are worried sometimes. People are scared about, how do I make it all work? So we're going to try to reduce that pressure that we put on ourselves as lawyers to show that there are all sorts of different ways that you can get involved, all sorts of ways that you can make your difference, your mark, while helping others. And we'll give you some tips so that whatever way you choose, you do it in a way that's competent, that reduces your risk, so that you're not worried about, whether or not you're going to have to call LawPRO. But if you do, you know that LawPRO's there also. And so I've done enough to set the stage. Why don't we go around the table? And I'm just going to start with Erin for no other reason than that she's first on my screen. So Erin, why don't you say good morning and tell us a bit about your practice and what you do?
Hi, everyone. My name is Erin ORourke, and I practice in Ontario, and all of my clients are in Ontario, but I'm actually coming to you from Halifax today. So I just wanted to acknowledge that I am on the ancestral and unceded territory of the Mi'kmaq people, and this is covered by the Peace and Friendship Treaty. So I do a completely remote practice. When I got called to the bar, it was 3 months into the pandemic, and we didn't really know what was going to happen. Thought it would be over by the fall. That's funny to think about now. But when I was looking at what to do next, my cohort was sort of the first one to go through that pandemic hire back issue. No one really knew what was going on, when the world would return to normal or semi-normal. So hire back was not a big thing. And I remember just sort of looking for jobs, not being able to find anything that really fit into what I wanted to be doing. And I turned to my boyfriend and said, oh, what if I just go out on my own, sort of half joking. And to my surprise, he said, yeah, do it. And so I started researching and looking into how to practice on my own and how to make it affordable. And so I looked into all of the different things that I would need, and practicing virtually means that my costs are quite low. So I was able to sort of get off the ground. And my original goal was to be able to make enough money so that I could get off CERB, back when CERB was a thing. But it's now been just over a year. So it's something that's been working. So I'm excited to share a bit about how I've incorporated access to justice into my practice and sort of clumsily fumbled through the last year of my first year of practice.
I don't know about clumsily. I think you're learning as you go, and it's
Yeah.
iterative, right? So
Yeah.
no problem. Okay, Neha, you're just next on my screen. So why don't you say good morning?
Good morning, everyone. I'm joining you from Cornwall, Ontario. I live in Montreal and I travel to Cornwall for work. I'm an Ontario trained lawyer, and my marriage took me to Montreal as a result of my husband's job. And I travel about 45 minutes to get to my office every day. I have been struggling with the access to justice question since I started my practice in Cornwall in 2014. And at that time, pre-pandemic, if there ever was such a time in our lives, the question was, how will anybody in this town where I've never set foot, how will anybody take me, a non-white young woman with a baby strapped to me, how will they take me seriously as a criminal lawyer? And so it wasn't just an access to justice question. It was, does anybody want to pick me as their lawyer? And what I struggled with at that time was, and the question that I had in my mind, the big question mark in Cornwall was, what is the unmet need, and how can I make it happen? And where I found my niche really was not just in legal aid certificates, but in that really sweet spot where it wasn't a lawyer's full retainer, because a lot of people can't afford that, but in sliding scale rates. And it was where I was able to make my mark and able to build my clientele with reduced rates. I can tell you that I was not met with a red carpet from other lawyers by offering those services. I was immediately seen as a competitor, but I held my resolve. But it was really important for me to make sure that people had access to representation that they could afford and that was high quality. And so as a new lawyer starting out and building my reputation, that's where I started. And work got very busy. Adding to that, what I was able to do was I was able to give community members my time and a lot of patience. And what I learned early on in my practice was the unique skill of being able to break down legal information in very simple terms. So if you're explaining, complex legal terms like actus reus or mens reus, all those really interesting legal Latin terms that we like to throw around at Christmas dinner to make us sound very smart. If you can break that down for a community member, they will be grateful, because remember, your clients think about their legal issues every single day, every single hour of every single day. And it's not until you yourself go through a legal issue as a plaintiff or a defendant or as an accused person or as a complainant that you really understand that factor. And so being able to break it down, be present, be available, be local, have a mainstream practice, all of that factored into building access to justice in Cornwall. And so now we have a real community presence in Cornwall. It's been 7 years. And all of the same questions bug me every day. Can I do this? Am I a good community member? Am I a good enough lawyer? Have I met my clients' needs? Am I on time for the access to justice practice section today? Is my child on the bus, on the school bus? Do they have their lunch? Do they have their lunch? Oh my goodness, do they have their lunch? Am I on time for the access to justice practice session? I can't remember. Did my materials get served on time? I can't remember. All of those same questions bother me. But at the end of the day, having a local practice and meeting local needs has been my priority.
I'd be remiss, Neha, thank you for that overview, but I'd be remiss if I didn't mention that Neha also has a beautifully written, heartfelt article that she just published in the Golden Thread, which is a new criminal law specific magazine that Peter Sankoff has released, describing that journey of hers. And I'd encourage those of you in the criminal bar specifically to have a look at that new publication. But Neha really brings that humanity of trying to attract clientele while maintaining her sense of self in Cornwall. It shines in that article. But thank you for sharing that starting point and we'll get into more of it as we go. Will, why don't you share with us some of the amazing work you're doing as well?
Sure. Thanks, Judah. Erin, I just want to begin by saying how jealous I am of the fact that you're in Halifax. As a born and raised Maritimer, I can't help but feel cooped up in my corporate tower in the financial district while you're enjoying the seaside life right now, but I'll get home soon, I hope. Yeah, just to talk a little bit about my perspective and how I come at this. So the first thing I want to underscore is that, in my experience, there are some people in the sort of big law world who think that access to justice is for small firms, sole practitioners who do criminal family employment work. I think these people are wrong, and they're undermining the legitimacy of their own businesses. Not only do big firms have a fantastic capacity to increase access to justice, and not only is there an imperative to do so ethically, but increasingly our clients are expecting it from us. So it is a business imperative, and they're right. So, in terms of my own involvement for a long time, I had in the back of my mind that I wanted to figure out a way to contribute to the LGBTQ2S community, of which I'm a member, which I'll call the queer community. And so, for years of my adult life, I wasn't like a diehard activist in the community, but I've spent a long time sort of wondering and sometimes honestly feeling a bit guilty about not contributing to my community, all of which is to say that it's never too late to get started. So my opportunity came. I was lucky enough to be coming into McCarthy's around the same time as our Inclusion Now program was being assembled. And just briefly, for those who don't know, it's a 5-year commitment by the firm to advance diversity and inclusion in partnership with 5 different equity-seeking groups, one of which is the LGBTQ2S plus community. So as part of that pillar, we're developing a formal partnership, as Judah mentioned, with the 519, which is the queer services organization in Toronto that serves all of Ontario and oftentimes beyond. And one aspect of that partnership is a pro bono program partnership that I'm fortunate to be leading. And so one of the main initiatives there is what's called a trans ID clinic. And you may or may not have heard of one of these types of clinics before. There's a few of them that are being run around the country right now. And basically how we run it is that the 519, of course, has a base of clients who are in need of all kinds of supports related to, in this case, their gender identities and expressions. And so they do client intakes, and then we have a sort of system set up here at McCarthy's where we'll have each client partnered with an articling student or a summer student who will walk them through the amazingly complex and often strangely expensive process of changing over your various government issued IDs to reflect your chosen name and your true gender identity. And so basically that's the sort of mandate of the clinic. And as we round out our, I guess, first 12, 14 months in operation, I think we've offered assistance to over 70 individuals now who are aligning their IDs with their gender identities. And I have to just give credit to our outstanding articling students. I'm the coordinator of the clinic, and I have lots of client interaction, but they're the real face of it. And that's something, we're lucky to have that capacity to do that here. And it seems seems to be going well so far. One other initiative I'll just highlight very quickly is that I've been lucky enough to become involved in more recently is that McCarthy's has a client who was a Baptist pastor who was fired from her job after coming out as trans. And now she's commenced an action against the church, and we're representing her in that. So I won't go into all the details, but it's an example of how I think you can grow and build a certain amount of expertise or experience helping particular communities access greater justice, because they're very different sort of initiatives, but both sort of have a common thread of serving a particular community. So for me, just kind of a couple of quick tips, I guess, that arise from my personal experiences: to start with your own personal priorities. If you want to be motivated and engaged so that you don't want it to feel like a chore, and so it's an area of your practice where you can actually pick something that you really want to do. And when you have a couple of ideas bouncing around, you can refine those by looking for an alignment between your personal priorities and, say, your firm's priorities, your client's priorities. And for me, that's the overall mission of advancing diversity, which is a key sort of goal of McCarthy Tetra right now. And then you can sort of drill down into specifics, have conversations with your others in your firm or others in your community, and take it from there. So that's kind of how I come at this access to justice question.
And with amazing results through the 519. So it's wonderful for all these stories to be shared. And Leslie Ann joining us today. Why don't we pass it to you and go ahead.
Thank you. Leslie Ann Saint-Moore and Indigenous Ottawa Valley Nadonjaba, Makwa Dodam. Hi, my name is Leslie Ann Saint-Moore. I'm originally from the Ottawa Valley. And I come at this issue of access to justice, I think, a little bit differently than the other folks who have already introduced themselves today, in that my role in access to justice isn't technically by providing any legal services. I am a board member of Aboriginal Legal Services, which is, for folks who aren't familiar with ALS, is an organization which is based in Toronto, but provides legal services to Indigenous folks across the province, as well as doing a lot of work in strategic litigation and advocacy, including at different levels of Court of Appeal, including in different provinces and territories, as well as at the Supreme Court. And Aboriginal Legal Services has been around for just over 30 years now. Last year was our 30th anniversary, which was very exciting. And for me as an Indigenous woman, it was always very important that I give back to my community with all of the privileges that attending law school and being a lawyer has given me. But I also know that I'm not cut out for family or criminal law and being able to provide those services directly to a client. I do not have the emotional stamina, and for anyone who does it, all the respect in the world, I don't know how you do it. But there are other ways to be able to support my community in that way. By being on the board of directors, I provide no legal advice, but I get to support our lawyers in doing the work they do. I get to support our strategic litigation and advocacy for the rights of Indigenous people in the criminal justice system, in family law systems, child welfare systems. And it allows me to continue to give back every day while practicing the types of law that I enjoy and that don't entirely burn me out and make me cry every day. And the other side of what I do is, as Judah very kindly mentioned, was the CPD I did on September 30th, because as Will mentioned, certain communities have certain needs that aren't always met by the legal system as a whole, and that folks who aren't familiar with that community aren't always aware of. And so for me, part of advocating for access to justice is advocating for a legal profession that understands the needs and history of Indigenous people, because Indigenous people will enter interactions with the legal system for a variety of reasons, and their needs are always going to be a little bit different because they can be influenced by the unique legislation which applies to Indigenous people. It can be influenced by their history and the systems within Canada. And so by helping other lawyers and paralegals in understanding that history and understanding that context is another way I can contribute towards access to justice, by helping to ensure that Indigenous folks whenever they encounter a legal professional, whoever they may be, can better serve them. And so I think it's really important that folks realize that even if you don't have the expertise in what are typically seen as kind of access to justice fields of law, there's still a lot you can do to be supporting access to justice for all kinds of folks. And as well, for me, it's really important that I say this as well, that especially when it comes to Indigenous folks, there are aspects of access to justice that I think are a little bit unique, in that I also think it's really important that, as someone who focuses on Indigenous and environmental law as well, that we remember that for Indigenous folks, access to land and treaty rights and Aboriginal rights is also a really important justice issue. And I do focus on as well finding ways to ensure Indigenous folks have access to those kinds of remedies as well in my work, which are not so typically seen as a fundamental access to justice issue.
No, thank you, Leslie Ann. You know, when you go around this panel, I think it's pretty clear that there are really all sorts of different ways to give back or to just be involved in access to justice in its different forms. And so, you know, you've heard already of some who are out there, and access to justice is what is baked into their practice DNA. You're hearing some who are doing it through legal aid, some through sliding scale, some through pro bono, some through volunteering with legal organizations. You're seeing direct service, public legal education, board service. So there are all sorts of different ways that you can get involved. And you can see, regardless of where you're located, regardless of your firm structure, whether you're solo or in a big tower as part of a national firm, there are all sorts of ways to jump in. And as Will said, it's never too late. So let's talk a little bit. Let's move to that second pillar of the program. Let's talk about finding that balance and finding those inroads. And so, Erin, maybe I'll start with you, because you've given this a lot of thought as you set up your shop.
Yes, I did. And not to start off with too cheesy of a story, but I specifically chose this mug today. One of my friends, I was working at Banana Republic before I went to law school. And when I got in, my coworker got me this mug, and it says, "Let what you love be what you do." And it's been my favorite mug throughout law school and practicing. And so I thought it was a very fitting mug to use today as we talk about, you know, finding that balance in your practice and finding work that fulfills you. So as I mentioned, I think it was kind of a clumsy struggle through the last year, is trying to find that balance. Because it is very difficult, especially as a new lawyer with imposter syndrome, to find your worth in charging. So not even on purpose, I did a lot of free work, I realized, throughout the first year. And part of that was also, I was a newly licensed lawyer and just so excited to do work that I just took whatever came my way. But I found throughout the year that was really draining. I had a larger practice area, so I just, you know, was like, okay, well, I did tenancies at the legal aid clinic in Windsor, so I'll do that because I know how to do it, kind of. So I'll throw that in there. And oh, I did some litigation in articling, so yeah, I'll throw that into the mix as well. But I found it pretty hard to balance lots of different practice areas. So in the spring, I cut down. I mean, I started off with saying Erin ORourke Law, Employment and Immigration, but I still kind of did some other stuff. But then I really focused it back down to employment and immigration. And a big thing that helped me in finding a balance was just taking a look at how much time I was spending doing work for free. And at first glance, it's really easy to say, well, it's just my services, it's just my time, it's okay, this person really needs help, let me just do it. But what I didn't realize was how much time and energy that was taking up, that I didn't have enough time to actually properly take care of myself and to make sure that I would be able to continue practicing. I mean, I started off practicing as right out of articling, no savings, $175,000 in student loans, and just went for it. So it was quite a fumble getting there. And when it's just solo, it's just you're the one that's answering the phone. I still do Law Society referral service. So I do a lot of free consultations. It's really hard to separate yourself from those stories. And it's really easy to just get caught up and say, you know what, I'll just do this one and then I'll find more work to help me live and eat next week or in the next case. And so I started to realize that if I wanted to stay practicing a lawyer and have this control over what kind of law I practice and the way I practice, that I needed to find a better balance. So I applied to be impaneled on the immigration legal aid panel, and I was accepted in the early summer months, which was a huge game changer for my practice. It allowed me to take on files that really filled me up and that I really enjoyed, but also I got paid. You submit it and 2 weeks later you get money. So that's great. So that has been a huge change in my practice. And if pro bono files come along and I have the time, capacity, and ability to take those on, then I can. But I think really narrowing my practice areas and the types of cases that I take has really helped. So now I do a lot of detention reviews for immigration, which is really interesting, hard work. Often you get disclosure the night before or the morning of from CVSA, and you head into either a 48, 7-day or 30-day review. So I really enjoy the work that I'm doing now. I don't have to worry as much about if I'm going to make it to the next month and stay in business. So it's definitely been a year of growth and learning, but I think it's hard when you're a new lawyer and you're starting off. You really just want to use your legal skills and help as many people as you can. But I sort of got to a point that I was just so burnt out and unable to help in the way that clients need, that it almost is a disservice if you're trying to do too much. Another option that my uncle actually suggested to me, he's my financial advisor, and he told me, you know, Erin, if you want to do this, it's up to you. If you want to keep being a lawyer and practicing in this way, you need to make money to be able to pay your bills and your student loans. And I understand that you like to do pro bono work, but why don't you make a pro bono budget? So whether that's a certain amount of hours per week or month or year, or a monetary amount of pro bono work that you're willing to take on, that kind of helps in regulating how much pro bono work you can take on and ensure that you're able to serve your clients. Because if you are spending way too much time doing pro bono work and trying to do your legal aid files and trying to do private retainers, you're going to get burnt out really fast, and you won't be able to serve any of your clients, no matter what method of payment they're using. So I think I've found a good balance now. I do a lot of legal aid certificates for immigration. I do private retainers mostly for employment law, and I do some pro bono work here and there, and volunteer at like the Pro Bono Ontario hotline. So there's lots of different ways to mix it into your practice, and different, you know, options you can provide to clients, even in private retainers, like unbundling your services, providing sliding scales, contingency fees, which I don't do, but other lawyers may. But I find giving clients the option of different payment methods is really helpful. So one thing I like to do as well, and this kind of grew out of the need that a lot of clients were calling me for through the Law Society referral service. And they just needed to be pointed in the right direction. No one was really telling them what forms they needed to fill out, what they needed to do, but I didn't have the time to provide that service to them in full. So what I started doing was these sort of like strategic consultations where for a much smaller fee, I can take a look at what they're doing, point them in the right direction. They can follow up with me. And it's sort of like coaching them through what they need to do next. Because it doesn't make sense if you're dealing with a matter where you're only going to get, $1,000 back to be spending a bunch of money on a lawyer to try and get that money back. So doing little micro services like that can also help in providing some greater access to justice, because it kind of helps them get on the right path.
Well, Erin, that's incredible. I mean, already just relatively new into practice, and we've got legal aid, which, you're going to get paid, right? And so
Yeah.
it covers that tranche, covers the overhead,
Yeah.
and you've kept overhead low by design. So a legal aid rate, it allows you to do what you want to do with your practice. And then setting these goals, setting these budgets that include pro bono is a fantastic way to make sure that you decide that you are going to do it, but within your limits, because it's a marathon, not a sprint. So lots of great takeaways here. And Neha, you went through this too. I mean, setting up shop in Cornwall, and you teased us a little bit with the rate system that you do. So tell us a bit about how you've made it work. Do you do legal aid? Is it, what's your mix?
So philosophically, I believe in legal aid, and therefore I take legal aid. Philosophically, I also believe that those who can pay should pay. And that's the foundational underpinnings of our legal aid system is everyone should be represented, and those who cannot pay should have the assistance of the state, given the jeopardy that they're facing. So I'm a big believer in that. And everything that Erin talked about, I'm just sitting here and I'm listening, because I feel like, the big sister who at 10 years of practice is saying, yeah, I went through that. Yeah, I did that. And I can tell you that I also graduated with close to $200,000 in debt. And that's back in the olden days when law school tuition in Toronto was only $20,000. And I say only in air quotes. And living in Toronto, going to undergrad, helping my spouse pay for his education, all of that added up. And so coming right out of law school and articling, working for myself was a daunting task. And luckily I worked for someone for 2 years. I worked for a firm for 2 years. But after that, because of the move, I had to break out on my own. But it's those golden handcuffs of law school debt that really are a deterrent. And there was no fancy big firm in New York saying, I'll pay your law school debt for you if you come work for us. It doesn't work that way in criminal law, and legal aid certificates were certainly not saying that. So I had that, adding to the fact that I also had our first child in first year of practice. And during articling and as a start to practice. And so we had a lot of financial obligations. And in the beginning, when I started my practice in 2014, I thought to myself, well, I just want to help everybody. And I want to make sure that everybody has a lawyer. And if they need me, I'll do it. And I can tell you that the person and the relationship that suffered the most, and I'll put this out there, is it was my marriage that suffered, because my husband was essentially bankrolling on a new professor's salary. He was bankrolling our home, our household, my practice, my lifestyle, our children, and my law student debt. And it was not an easy discussion. So access to justice had to have a new conversation. We had to have a new discussion about what access to justice would look like at Chug Law. And at the same time, I was thinking, I'd have a client come in and they'd say, I have a criminal law issue, here's my certificate. And will you also take my certificate for my family law issue? And I would think to myself at that time, well, I don't want to leave money on the table. Like, this is a person with money and they're ready to give it to me. How can I just turn it away and say no when I also have all of these bills to pay? And I could probably find the skill set to do it. Okay, so that was a really bad idea, because then I was just doing everything for everyone, missing deadlines, overwhelmed with work, and overwhelmed with new work in a new place. And this was pre-pandemic, when we were driving everywhere to every courthouse, making every deadline in every different courthouse. And on top of that, learning the practice and procedures of every single courthouse. Because as we've learned from COVID, no two courthouses are the same in terms of electronic filing. No two courthouses were the same pre-pandemic in terms of courthouse filing. So after the 2-year mark or so on my own, I realized how overwhelmed I was, and that I needed help, and that I needed the help of other young lawyers. So I started to find in the courthouse other young lawyers who were also probably at Erin's phase, where they were, just starting out. And I said to them, come work for me. I don't know if I can pay you a salary, but we can work something out on a per file basis. Come work for me, because I want to make this access to justice thing work. I want people to have effective representation. I want them to have a strong voice in the courthouse. I don't want them to get steamrolled. But at the same time, I can't do this by myself. And so by approaching other people and create, that's how Chug Law was formed, by me going up to people and saying, come work with me. And the first person that joined me was a criminal lawyer. And that was at the end of 2015. And it was an excellent relationship. He started on a per file basis, because that's what I could afford. And then after that, a family lawyer joined us. And essentially what I did was, I had a box of family files that were all my files. I gave him 20 family files approximately, that I had been working on. And I said, these are yours now. And I took 2 weeks off and I walked away from them. And the clients knew it was coming, but I had to let go of my emotional attachment to the clients, and to the files and to the issues. And I had to let someone else do it. And I had to not micromanage him, and I had to not micromanage the file, because if I had stayed, I would have done that. So I walked away from it for 2 weeks and I let him do it. And that's how Chug Law was formed. And now we are a team of 5 lawyers, staff. We own our building. But it was about bringing in the right people at the right time. It is okay at the beginning to say yes to everything, because that is how you will learn. Because that is how you will learn to say no. And so think of it like, like a Christmas turkey, right? Like it gets really, really fat, and then you carve it down to the pieces that you want, right? You have to let it get really fat so that you know what you don't want there and what you can't manage in your practice. Yeah.
As a vegetarian, I'm not sure I can go with that analogy any further, but Neha, it's interesting because Erin as a solo is saying, here are how I'm creating balance. And here's the thing about access to justice, right? Is there's always unmet legal need. We know that in all sorts of different areas. Nobody on this panel is even talking family law. There are other panels about that. There's lots of great work in family, but there is an endless amount of unmet legal need. We as individuals and as individual firms cannot solve these systemic issues individually. We can contribute. We can help individuals. We can help the system improve incrementally in the ways that we have under our skill set. But that means making these decisions to avoid burnout, to say no to files when they're really outside of our area of expertise, to be able to build our areas of expertise so we're competent to do the next one and the next one and the next one, and to build our professional relationship network, as Neha described, so that there's cover for when we need a break. There are partners or other solos out there who you can trust, who can be that second layer in case you need to step away, or who you can bounce ideas off of, or who you can refer the work to when your volume is just at peak. So lots of different ways to keep the balance in there, and lots of ways to make sure that your bottom line is protected as you go. Because at the end of the day, with overhead as low as it is, and there was a question to Erin about how did she start up, and she started up virtual, right? And so the overhead is lower than it's ever been, thanks to technology and thanks to clients who now are expecting online delivery of legal services and digital first strategies where they have access to that. So let's not forget that there are many, especially in rural and remote areas, where that is not the reality. And on certain reserves, there are significant issues for access to internet. So let's not paint the entire province in one brush, but there are many with unmet legal needs where you can serve without all of the historic overhead. And so even a low bono, even a legal aid will pay the way. Sliding scale rates can help you pay the way. And then you can also deliver on the pro bono systems as well. So let's talk a little bit about competency, because Neha, you started in there, and there are some myths out there about, well, it's a freebie, so whatever, or that goes to the bottom of the line. And we just need to make sure that we're all clear here. So let's talk about some of those lessons you learned about the access to justice in the community you were serving, and some of the hard truths about being a professional, even if you're not being paid.
So first and foremost, the biggest learning curve for me as a sole practitioner was learning how to manage my business. And there is absolutely no law school class and no training. There's no articling. Nobody ever teaches you how to do that. And talking about overhead in pre-pandemic days, I outfitted a beautiful rental with beautiful furniture. And I learned 2 years later that you had to actually pay that credit card down. And I learned that while also being audited by the Law Society for my trust accounts, which every new lawyer has to go through. A personal story is that during that audit, I was in my first jury trial, and I didn't realize how serious a financial audit was. So I was sitting there going, well, I got to get back. I got to get to my jury. So the Law Society froze my trust accounts, with all due respect to the Law Society, and thank you for doing that, because they froze my trust accounts for approximately 2 days. And it was a hard lesson in, you can go 1,000 miles an hour, but if you are not competent in what you are doing, someone is going to freeze you. You are going to stop in your tracks, and something or someone is going to freeze you. So that was my first area of lack of competence, complete lack of competence. And that's when I learned that I had to ask for help. So I had to ask a bookkeeper, I had to hire a bookkeeper, I had to hire an accountant. I was incapable of doing that by myself. So that's the first area of competency where I had to ask for help. The second area of competency were areas of law where I just was not ready, and my head was really big, but I was just not ready for it. I thought, well, if they can do it, I can do it. But areas of family law, child protection, it's not for the faint of heart, and it's not for dabblers. You cannot just dabble in different and very discrete areas of law, because you will come up against an expert, people who have been doing it for 20, 25 years, and they will shake their head at you. Your reputation will suffer. You will be talked about in the library in terms of your lack of competence in an area, and you'll be taken advantage of in court and in pleadings. And you don't want that, because your client will suffer. So take advantage of mentorship opportunities, ask for mentorship in your firm. And if you have a law firm, if you have younger people under you, give them files incrementally that will help them build on that staircase of learning. So I have 2 associates. And one of them I say, okay, she hasn't done this yet. I'm going to give what otherwise I would be doing. I'm going to give this to her because she's going to learn from it. So as a mentor, give people learning opportunities. As a mentee, ask for those learning opportunities. Ask to sit in on things. Spend a day sitting in bail court all day long just to see how things are going. Spend a day sitting in plea court. Spend a day watching motions, family court motions. Let the trial coordinators know that you want the Zoom links for a motions date. They'll let the judges know why you're there, because they'll say, why is Miss Chug in my Zoom court? Does she have a matter? Tell trial coordinator that to tell the judges that you're there for a certain reason, just to watch. And then maybe, and this has happened to me, maybe a judge will keep you after and explain what has happened to you. But take all the opportunities to learn that you can, because discrete areas of law, every area of law is not for dabblers.
Well, that's for sure, and that's a LawPRO key message. Law is super complex. Gillian Hadfield talks about how we live in a law-thick world, and so the more we as lawyers can get our area of law expertise down, the easier it becomes to serve people and serve them really effectively. And if you've got that career path that leads you to particular expertise, you can share that expertise much faster and get people further along, instead of running 1,000 miles an hour in the wrong direction on a file and hitting a wall. So Naya, those are great points. Will, I was wondering, I mean, in a structured environment like the 519 program, I mean, you were there from inception, now you're supervising people. I'm wondering what sort of systems a firm puts in place. And Neha mentioned some. I mean, this idea of the staircase is brilliant. And so you're baking in that as well. Why don't you tell us a bit about how that works to ensure competency in the program delivery?
Certainly. So, Neha, you mentioned that certain things are not for dabblers, and that's totally right. But there are other areas that are a little bit lower risk. And for us, we're not in a litigation scenario. We're effectively helping people navigate a bureaucratic process. Usually the very worst outcome is that an application is done wrong and gets sent back, and so we do it again. And that's not to say that competence isn't key, and it is, because we have a huge volume of people we're trying to serve, and so we need to get through applications and help clients in an efficient manner. However, like if you are concerned and you're looking to mitigate risk and you're looking at any concerns around competence, you can strategically pick areas that have a lower risk profile, and this is one of them. We have. It's, as I mentioned before, it's our students under close supervision, but it's our students who are the day-to-day interaction with the client. And then, of course, like before an application goes off, like one of our supervising lawyers, including me, will review and commission and meet with the client before the process is complete. But there's sort of just different options and different roads you can go down in order to sort of strategically mitigate your risk in that way, and that's almost like a sort of like a cottage industry model, if you will. So like there may be a sort of a discrete service, as in the case of a trans ID clinic, where it's needed in the community. You can get good at it and efficient at it, and which is not particularly complex. And we've kind of found one niche in that regard. There are other files that are pro or low bono that we're working on, like the action for the Baptist pastor, as I mentioned, which is uniquely complex and higher risk, and we're all over that in terms of bringing in all relevant expertise from different parts of the firm. It is at its core an employment matter and a human rights matter. And interestingly, I'm a business lawyer. I used to be in the litigation group. I am no longer. However, I'm running this file with the assistance, and I'm lucky to have it, of our amazing employment group of our top-notch constitutional litigators, and with the consultation from advocates in the community who are supportive of and passionate about trans causes, and there are cultural competencies that as a gay man, I don't necessarily I don't profess to understand the full experience of what it is to be trans and to navigate that process. I'm a part of that community, broadly speaking, but we need to draw on the cultural competency and expertise of others in the community who know more about this and who are happy to talk about it, in addition to our own clients. It's, you know, there's a range, I think, of expertises that may be required, and a range of risk profiles. And so, you know, I've found that if you need help, and I haven't always practiced at McCarthy's, I've practiced in smaller venues as well. And if you need help, maybe senior lawyers at your firm, but lawyers outside of your firm, I've been amazed at how willing people are to help, especially if it's a low or a pro bono matter. The community of lawyers is extremely supportive. And if you don't just want to randomly call someone up, I think that, you know, you can be supported through the Law Society or through LAWPRO on these kinds of things. And yeah, I think there's just some great options to make sure that you are meeting your competency needs and lowering your risk profile. And I know that can make people nervous in terms of diving in, but I think there's so many great options to sort of mitigate that it's worth taking advantage of the resources that are there.
Well, thanks, Will. I mean, it certainly makes sense to toe dip rather than dive into a highly complex area when you're first starting out. Certainly no first-year criminal lawyer is going to do a pro bono murder one, you know, first-degree charge pro bono, and nor should they. But, you know, for some of these, you know, it doesn't matter whether you're at a big firm or a small firm, and Will's right. Like, it's great to be able to walk down the hall and get that expertise on a low bono or pro bono initiative. But Erin and then Leslie Ann, in smaller, you know, solo to smaller firm settings, what's the dynamic? Erin, how are you finding that you're building your competency through reaching out to others? How's that going?
Yeah, that was probably the number one concern I had about going out on my own as a new call. And one thing that really helped me is I reached out to a lot of different solo lawyers and lawyers that were working in small firms when I was looking at going out on my own. And I made a really good network of different lawyers that I can turn to. So even though I'm not in a law firm setting, and I am just on my own, I have a variety of different lawyers that I can turn to for my practice areas. So that has been really important, and that's all been done through the pandemic era. So most of these people I've never met in person, but I can message them and ask them, you know, sometimes it's something so small as, what address am I putting down for the Minister for Service for these Section 44 submissions I need to submit? And you're looking online and you're like, I don't know which address I'm supposed to use. And so you turn to a lawyer that's more senior than you, and they can point you in the right direction. So it's a bit different than being able to walk down the hall like I was able to for the first part of articling. But I found that many lawyers have been extremely helpful and willing to assist.
Amazing. And Leslie Ann?
I've had a similar experience, I think, to Erin, in that while a lot of my access to justice work has been through the board, being a new board member, I didn't know a lot about even the history of the organization I was serving. I didn't know a ton about the obligations of being a board member and what my actual risk might be. And so when I was being introduced to the board and asked if I wanted to get involved, I was able to talk to senior board members and say, you know, what exactly does this look like? What are my obligations as a board member, and how can I make sure I'm fulfilling them? And I got a lot of great advice. And not only was it from people on Aboriginal Legal Services Board, but I've also been able to help facilitate conversations between senior board members at ALS with new organizations that are setting up their own boards, or folks who are considering board work for other organizations, to be able to do some of that sharing of best practices and advice and tips and things like that. That is so, so important, especially I think for board work, in the sense that there are a lot of organizations out there that have boards set up but don't really know what they're doing when it comes to the legal side of board governance. And so Aboriginal Legal Services generally doesn't have that problem. If anything, we have too many lawyers involved. But it's been really great to be able to be that person now that other folks can ask about, how do we set up a board? What does that look like? What are our obligations? And to be able to serve access to justice in a really broad sense, not only in terms of Aboriginal legal services, but other organizations that focus on supporting vulnerable populations.
Leslie Ann, you're coming right back to lawyers as lawgivers, right? Which is a lot of the reason why we go to law school, is to be able to not just hoard the law, but be able to translate it and break it down and share it. And so that's a lovely other path, is through board governance, which is a really important part of not-for-profits and charities and other institutions. And I've served on boards too, and I know exactly of what you speak, especially when there are too many lawyers on the board. But it's a really helpful piece where there's a value add from our training and from our understanding of things like fiduciary duty, or independence, or confidentiality, or all these key principles of governance that we can help for an entire group to be able to understand. So again, just another different way that we can slice and dice to use our legal skills in ways where we amplify and we share. And so thank you for sharing. So we've gotten a lot of different paths in so far on the program. We've talked a lot about how there are different ways that you can help for access to legal services generally, which is part of, but of course not the full solution to access to justice issues. And we've talked about different ways that you can make your practice viable while contributing to access to legal services. We've talked about some of the competency steps, some of the things you want to be cautious about to make sure that you maximize your impact, that you're able to help people as effectively as possibly, as clearly as possibly. So now we're going to start, we'll talk a little bit about some of the other resources and some of the other practice tips to really help you regardless of where you jump in. So we'll talk a bit about, whether it's on pro bono initiatives, or other initiatives, all the way through to public legal education or serving on a board. But why don't we start with the traditional model, and then we'll talk about board as well. But on the traditional model, the first piece is that intake. And so we need to remember that all the regular rules that would normally apply around conflict of interest will apply, except for in certain limited circumstances, like if you're going to a PBO program, or you're doing a day of court program. There are certain changes which may apply, and you'll need to check the rules before, or call the Law Society's practice management hotline if you're not sure. But if somebody just walks into your firm, or an organization walks into your firm, there are protocols that need to be followed. So Will, why don't we start with you, because I know that the conflicts are a significant ethical issue that big law firms are very careful about, given how large you are and how many different types of clients you serve. So why don't we start with you about that screening that's so important?
Sure. I'm happy to speak to sort of how we're looking at conflicts in the context of the work that I'm doing. And so my practice is to run all of the normal conflict checking procedures with each individual trans ID client that we bring in. And that's it can be burdensome. There are a lot of them. And it's not necessarily the case that is always done. So I have heard, but the experience has been that to the extent that there are any conflict, or any hits on the conflict search for our pro bono clients, which really is rare, the matters have been completely unrelated and on to other matters that we've worked on for existing clients, and they have been considered and cleared by our counsel. But this is one area where I think there is some hesitancy. There may be, I think, a general perception at some of the bigger firms, especially, that we won't be in a position to help individuals because sometimes we act opposite them for bigger institutional clients, for instance, in the employment context. And I think those fears are a little bit overblown, and the real issues come up less frequently than you would think. And I think people are worried about business conflicts just as much, if not more, than legal conflicts. Nevertheless, what I think is the critical point is that, yes, we have that system in place, obviously, for clients generally, and yes, we apply it in this specific circumstance. of of running a pro bono clinic. It's high volume and it can be annoying and burdensome, but I do think that it remains important.
Thank you, Will. And Erin, I'm just going to pick on you. Sorry, but you're a solopreneur. So how do you deal with it?
Yeah. So I started off my law firm with systems in place, so that once I got clients, that it was already in place. I know there's a lot of different ways that I could have waited until I got more volume to put like my online systems into place. But those were some of the first things that I bought were online systems, so I could have a very organized system to do conflict checks and to have all of my contacts, no matter if they are pro bono or private retainer or legal aid, all in the same spot. And so that was really important for having that in place, because once the volume picks up, it's really hard to go back to the beginning and get all your ducks in a row. So starting with good habits right from opening your practice are really key in ensuring that your conflict searches and all the procedures and systems are in place for all of your clients.
That's great. And of course, there are ways to offer services that are more limited, where you can work with a pro bono partner who also will be doing conflict screening, and where some of this gets baked in. So if you're going to do a day of pro bono Ontario program, you can work with them. And if you have actual knowledge of a conflict, like you've acted against this person on this matter, then you're not going to take that call that came in. But there are systems to bake it in as well. If you're not sure whether you're comfortable with the conflict screening for pro bono matters, or concerned about how much time that might take, there are day of programs, and there's also Pro Bono Students Canada that has a family law program, and they do conflict screening as part of that. So you can work with pro bono institutional partners if you're worried about how to do this properly. Let's talk a little bit about communicating with clients. There's no one size fits all, but what I tend to tell people is, you want to get into, and if anyone's ever seen me before, sorry, you're going to hear it again, but what I call the CD loop. So think about a compact disc player, and you're going to want to, it spins, it makes music, it's constant. You don't want it to skip, you don't want it to slow down. You kind of want there to be regular, you want it to be regular. And I think about that the same way for communication. I think of the CD here as communicate, document. So if you have a client who likes to just pick up the phone and speak with you, there's nothing wrong with that if you're comfortable with that, but you need to have a note. You need that documented somewhere. If your client takes email, then you can just, as soon as you're off the phone, before you go to the next task, write a quick email so that you both have the same note as to where you're at now, right? So communicate, document. Sometimes it's the same, right? They've emailed and you email back. Hopefully not just an emoji back, but hopefully, some sort of, yes, I agree to this next step, right? But the communication document loop keeps you and your client moving, in the same direction, keeps that music spinning, keeps you, aligned. And so, for a pro bono client or for a sliding scale client, I have to stress that communication, all of those ethical steps you would take, all of those practice management steps should be the same. So now you've got a different range of clients. You've got full freight, you've got legal aid, you've got pro bono. Why don't you tell us a little bit about, is there any balancing act, or is it you're in and that's the way it is?
I like to think that no client suffers from a different quality of service. So everyone, let me rephrase that. Everyone receives the same quality of service, no matter what their fee is and no matter how much they're paying. They're still entitled to a strong defense or a strong offense if it's a family law file. But everyone is entitled to my time, knowing what they're in court for, knowing what the next steps are. And a lawyer once explained it to me at the early onset of practice was that every single one of your files, no matter how much they're paying you, think of it that every single one of your files is on fire. And so that's how, I mean, I don't walk around, with, multiple fires, little fires everywhere, to borrow the title of a book, but I don't, walk around in that sense of panic, but I do think of every file as important and every client or community member as important. And from a strictly business perspective, and I work in a small town, that pro bono client that you have has family members, has friends who are going to ask them, who did you work with? And that name, Neha Chugh, is going to get out there. And that's largely your best form of advertising, is doing a good job on a file, whether it's pro bono, low bono, or the full rate. And so if you can do a really good job, no matter what the fee, you're going to have someone doing your advertising for you. And so what I like to do is I will email the client saying, and it's quick, it can be a dictated email that I can do from the car, that I can dictate from the car, and it'll say, this is what we just talked about. It was great chatting with you. Hope that's what your understanding was. And that's it. And the assistant can send it out, or it can be sent out later. But a quick note to Clio, that also helps, because that keeps and Clio is my practice management software. Everyone has a different practice management software if you have one. But just keeping a record of things. I like to text my clients and then take a screenshot of the text really quickly and upload it to Clio. But be careful when you're doing that kind of communication. Judah was just talking about the emoji issue. Before this panel, I was joking with one of my associates that he was trying to get minutes signed, and the answer that he got was a heart emoji. Said, is this your understanding? Are we ready to sign minutes? And the client sent a heart. And so is that a yes? Is that a no? Would it be different if it was a fire emoji? I don't know, but make sure that your messages are clear, because you don't want that to be what a reviewing court or what LAWPRO is looking at later. You don't want someone at Judah's office looking at a heart emoji trying to determine if it was a yes or a no on minutes of settlement. So be very clear in your communications. But my advice is that it doesn't matter how much someone is paying you. That is not your consideration when you are giving legal services.
And just to start with the intake, so we did the conflicts,
Yeah.
and Neha, you're spot on this. And I can tell you a heart emoji at the signature line of the minutes of settlement will not be binding. So, we all have to figure this out. But you've got that intake and you do the conflicts check. But the next step to building that client trust and the clarity of what you're going to be doing is to use a written retainer. And one of the things that we can do at that point is LAWPRO has template plain language retainer agreements, except for contingency fees. We have the link there, but I'd be remiss if I didn't mention that the Law Society and the Government of Ontario has recently reformed the way contingency fees operate to make them consumer friendly, to make them plain language. And so you can go and learn more about that at Practice Pro as well at the retainer page, but we are going to send you to the Law Society and all of their excellent resources, including checklists. But the bottom line is, regardless of whether it's limited scope, where we have standard template retainers that you can use and tailor for limited scope retainers online at Practice Pro, or whether it's a standard area of law matter, or whether it's a contingency fee matter, you want your retainer letter to scope out what you're going to be doing. And at times that will include scoping out what you are not doing. So if Erin is on for an employment law matter that arises out of a motor vehicle accident, somebody gets hit and is injured in a motor vehicle accident, does not make it to their shift that day and is fired, Erin might be doing the employment law matter, but is not going to be touching the motor vehicle component because she doesn't do personal injury law. So her retainer should say, I've been retained to deal with your employment law matter related to your being fired for not attending. I understand you're in an MVA, which is why you were unable to attend. You should seek legal counsel, or I have recommended that you seek legal counsel for that. I've given you the names of 3 lawyers. I am not acting for you on that part, right? And so sometimes there are intersecting areas. by having a good client intake meeting and, good, strong client relationship, you'll understand that there might be intersecting areas. You want to make sure they know what you're working for them on. Because sometimes somebody comes in and says, I've got a lawyer, right? Bingo, I'm in. My legal problems are going to be addressed. And of course, we know that we're more like surgeons at times. And so if there's something else that requires another procedure, we need to refer them. And so we need to swing that vine and help them with that no wrong door. We need to help open the next one for them. And so, really great to hear that there are a range of different services that are already being put on offer. And Leslie Ann talked about serving on a board. And, one of the things that LAWPRO also has, and it's in the materials today, is we have a board, sort of an article about serving on a board, on a not-for-profit board, on a charitable board, because we encourage people to do that. But you need to make sure that you understand the risks and opportunities and potential rewards in doing so. LAWPRO is the professional liability insurer for lawyers and for paralegal partners of lawyers. And we cover your professional delivery of legal services. We're not going to be there to cover potential directors' errors or omissions. And so you want to make sure that if you're worried about risk, if you're worried about insurance, you need to talk to the board and talk to the organization about that. You also have to think really carefully about the board work versus your professional work. So Leslie Ann does not act on behalf of ALST. She does not act, and they do not have a pre-existing client relationship. Right? But if she did, there would be decision points to be made about whether you could serve on the board, whether you could continue to act, whether you'd be getting off the record, no longer providing the legal services so that you could act on the board. So this checklist from LAWPRO helps you manage that so you can decide whether you want to be a lawgiver as somebody on a board, or whether you want to be a lawgiver as somebody who is in there with a client and acting for them and providing legal services, wearing your legal hat through formal retainers. So just one more way of thinking about that divide, one that you can think through, but where there's no wrong answer in how you decide to provide expertise and contribute to access to justice. So we're coming up to 10 minutes to 11 on the live stream of this event. And so we're going to open it up. The Q&A option is there. We've had a couple of live questions as we've gone. We encourage you to think through questions and put them in the chat function for us. As we do that, I just want to remind people that, and as the chat function has indicated, the program resources are now live. And if you go through them, you can see that there's everything from the very start. What we have is a getting started article that really talks about law firm innovation now, because right now, the barriers to hanging a shingle or the barriers to providing access to justice while keeping overhead low, it's never been lower, because bricks and mortar is not necessary for many areas of practice. So we have an article about cultivating your innovation mindset so that if you're trying to think about how to get creative to find your niche, your access to justice niche even, you can take that article and think about it a little bit. And then to get more granular in the execution of it, you can look at our business plan and law firm budget precedents and their templates, and you can find similar templates elsewhere. But just to get started, you need to think about this from a business mindset, as Neha said. These aren't skills that are necessarily taught in all law schools. So give it some thought if you need to about how you budget that out, and give some thought to Erin's views around, creating that balance. So then we can go to, you can use the Q&A function as well if you've got questions as we go through these resources. For limited scope retainer resources, Practice Pro has a starting point for you with some articles around areas to be of concern and to make sure that you are clear on your retainer. And if the retainer is going to scope out, if it's going to end up in scope creep, you need to sit down with the client and enter a new retainer. But don't be shy to try limited scope retainers. They're a great way to provide key legal advice, as Erin's coaching service demonstrates. lots of ways that you can help somebody along, and some way that somebody can come in for a first bite and they may come back, right? And then it's like law as buffet, as opposed to, law, where law, somebody's come in and is expecting a 10-course meal from the outset. So the next resources you have in the materials relate to pro bono and to finding your mentoring. There's also a link to our newly launched mentor programs guide. And we have some other materials there around not-for-profit management and practice management generally. And so lots of areas for you to deep dive into how you want to get going. In terms of the questions, we've got a good question that's come in around the difference between block fees and hourly rate. Does one of our panelists want to tackle that one, or do you want me to just go for it?
I can say that I do block fees primarily. I can say that as a criminal lawyer, it's becoming pretty standard, and it's an easier explanation to a client in that retainer. I will take you, I tell the client in plain words, I will take you from point X to point Y for this amount of money. After that, my daily rate is X, and I expect that it will cost you about this amount of money. So if I think that, and this, I'm just picking a number out of the sky, if I think that going from X to Y, which is either getting to resolution or setting a trial date, and that includes my review of the disclosure, my review of the circumstances, if I think that's going to cost me $1,000, and in my head, I know how many hours I'm going to be spending because I've spent an hour with the client. I know the circumstances of the case. I know it's going to be complex or not complex. I can give the client an understanding of how much time, what they can expect, and how much it's going to cost, which is the big question. The first question that I get is, how much is this going to cost me? And then once that trial date is set, I can say my daily rate is X per day. And I anticipate from my experience, this is going to be a 5-day trial, and this is what the total cost of it is going to be. And so I think that in criminal law, and I'm not too aware of other areas of law and how they're scheduling their hourly rates, but criminal law is moving away from the traditional hourly rate docket system. And I think that is an access to justice piece. We don't like to talk about money out loud, and we don't like to talk about how much we're making, but access to justice is a financial issue for our clients. And so being able to rethink how we charge our clients, not how much we charge our clients, but how we charge our clients, I think is a big question. I think Erin touched on it when she was talking about unbundled services, which you can offer flat fees for. That's my very brief answer to that question.
No, it's helpful now, because I think that both on the unbundled and on the block fee arrangements, and we've been trying to get candid about money here because it does matter. It's more than money for access to justice, but it's a part of the equation for many, and it's a big part for many. And it's important because lawyers are worried about making ends meet, and we see that in some of the chat and some of the questions coming in. So we need to get into that. But what we're seeing is, prospective clients, they need to be able to have some cost certainty or some understanding or some estimate. And an hourly rate doesn't help buy that certainty. And we're the lawyers, we have the expertise. We know what the disclosure will likely look like. We know roughly what the trial will look like. We know that better than our client anyway. And so if we can try to estimate that as best as possible and create that block estimate, that block fee amount, as opposed to saying, we'll just start working and we'll charge you later, or we need a bigger amount up front because we don't know how long this is going to take, then it helps create a cost certainty and helps build the client trust as well, because that idea of the cab that just keeps driving is no longer in that client's mind. We've got lots of questions here about how to reduce overhead, how to save costs, how do we make it work? We're not going to be able to get into that today, other than to say that today part of what will start is questioning what is your competent, safe, minimum viable practice. And if you go to the Innovation Mindsets article, we talk a bit about those sorts of approaches where you think, starting, what are the key requirements you need? And don't skimp about training, and don't skimp about education, don't skimp about time to dedicate to pro bono or time to network. But you need your computer system, you need your LAWPRO, you need your Law Society fee, you need a cell phone, right? You need some sort of document storage system, and then you are basically good to go. And so then it's a question of finding your CPD, finding your training, finding your mentors, finding your group that will be part of your legal community. But if you need an office, there are ways to find office space. There are ways to co-share with others that can build in the mentoring. But you can start with your minimum viable practice that is a safe practice. And when you have ethical questions or practice concerns, you reach out to your colleagues, you reach out to the Law Society's practice management advisors if it's an ethical issue. If it's a practice management question where you're not comfortable with somebody pressuring you or the scope of a retainer, or not sure if it's a conflict, feel free to call Practice Pro and I or one of my colleagues will respond. But think about that minimum viable mode as opposed to starting with what are the bells and whistles. Neha learned the hard way and is brave enough to share about failure, and not just here, but elsewhere. You don't necessarily need to buy, a beautiful couch, right? There are other ways where you can strip down the overhead as you're starting out. So we're going to have to wrap up, I think, at this point, but I really want to thank everyone for participating today and being part of Access to Justice Week. I really want to thank all of our panelists who, of course, in ways of our profession, have given their time pro bono today to help us all learn from them about how they facilitate access to justice in their everyday practices. Just a reminder that this program is eligible for 1.5 hours of professionalism credit for Law Society CPD purposes. It's also eligible for LawPro's risk management credit, which you can claim at lawpro.ca. The program will be available on replay at practicepro.ca/CPD, which is also where you found the program resources for today. And when the replay of today's program is ready, we'll send out a post via our blog at avoidaclaim.com. You can subscribe to Avoid a Claim if you want updates, but this will be available in the next few days. We want to thank the Toronto Lawyers Association for helping put this together, particularly Joan Rattake-Lang and Deirdre Harrington, who are Access to Justice champions and have been involved in Access to Justice Week in other events as well. Thanks to the Law Society for hosting and for organizing through TAG this incredible Access to Justice Week. I'd encourage you to check out some of the week's remaining events. This afternoon's is going to be killer. Check it out if you can. And help us. You're going to receive a program evaluation email. Feel free to complete it. It helps us determine how to structure our events for the future. So that concludes our program, but take care and thank you once again for joining us. We really appreciate your time. All the best.